Every senior lawyer knows they should verify the citations Claude produces. The hallucination files episodes have made the case so many times that a senior practitioner watching this can recite it back. The verification step is the one most lawyers skip. It is also the one the case law is now punishing hardest. The reason it gets skipped is not negligence, it is time. Proper verification, done the old way, takes 3 hours on a brief. The submission is due at 5. The choice gets made. This is Foundation's Episode 6, a protocol that takes the same verification step from 3 hours to 15 minutes every time before anything leaves your laptop. The honest answer is time. The lawyer who skipped the verification step on the brief that got sanctioned didn't think the verification step didn't matter. They thought it mattered enough that they wished they had time. The deadline didn't move. Something else gave way. That something was verification, because verification is the step that doesn't show in the final draft. The protocol below changes the math. When verification takes 3 hours, the brief due at 5 doesn't get verified. When verification takes 15 minutes, it does. The case law has not given senior practitioners a third option. Verify, or eventually you appear in the database. Make verification take 15 minutes and the choice doesn't get made. 15 minutes, 4 checks. Check 1, existence. Does the case exist? Real citation, real court, real year, real parties. 2 minutes per citation. Check 2, quote. Does the quoted passage actually appear in the cited authority? 2 minutes per quote. Check 3, proposition. Does the case actually stand for what you cite it for? 3 minutes per case. Check 4, currency. Has the authority been overruled, distinguished, or read down since? 2 minutes per case. Average matter has 6 to 8 authorities, 15 to 20 minutes total. The first check kills most hallucinations. The fourth check kills the failure mode that doesn't look like a hallucination. Each check is essential, and each check is fast. Check 1. Does the case exist? Open Osley, Westlaw, or LexisNexis. Search the citation. The case either appears or it doesn't. If it doesn't appear, you have a hallucination. The citation comes out. If it appears with different parties, a different year, or a different court than your draft says, you have what we now call a partial hallucination. Claude assembled real components into a false combination. Claude knows there is a case called Smith and Jones, and Claude knows there is a case in 2019 about negligence. But Claude has joined them in a way that doesn't reflect reality. The citation comes out, even though the components are real. 2 minutes per citation. Most hallucinations die at this step. Check 2. Does the quote actually appear? The case is real. Now you check the quoted passage. Open the case, search for a distinctive phrase from the quote, confirm it appears verbatim. The most common Q2 hallucination pattern is real cases with fabricated quotes. The case is real. The judgment is real. The quoted passage was generated. Search by distinctive phrase, not common words. Reasonable foreseeability will surface dozens of paragraphs in any judgment that touches negligence. The duty extends to circumstances which a prudent person would not have anticipated, is distinctive enough to confirm or fail in seconds. Pick a phrase Claude wouldn't generate by accident. 2 minutes per quote. Check 3. Does it stand for what you say? The case is real. The quote is real. Now the harder check. Read the headnote. Read the surrounding paragraphs. Confirm the case actually supports the proposition you cite it for. The third Q2 hallucination pattern is real cases, real quotes, but cited for propositions the case doesn't actually establish. The judgment said something close, in passing, in obiter, or about a different question. Claude has paraphrased the proposition in a way that sounds like the case stands for it, when on a careful read, it doesn't. This is the check that needs your training, not Claude's reading. 20 years of practice telling you, this case isn't quite saying that. 3 minutes per case. the check Claude can prepare for but cannot perform. Check 4. Is it still good law? The fourth check is the one Claude can't do for you. KeyCite, NoteUp, ShepherdSync, whichever of the equivalents your subscription supports. Confirm the authority hasn't been overruled, distinguished, or read down since Claude's training cutoff. Claude does not have current case law citators baked in. You do. The authority that was good law 6 months ago may have been read down by an intermediate appellate court last week, and Claude does not know. The case will exist, the quote will appear, the proposition will be supported, and the law will have moved on. Currency is the failure mode that doesn't look like a hallucination. The most dangerous failure looks exactly like a clean citation. 2 minutes per case, every case, even the ones you're sure about. Make Claude do the setup. Before you start the 4 checks, get Claude to lay out the verification table for you. Attached, your draft. Produce a verification table for every authority cited. 5 columns: citation, quoted passage, proposition cited for, confidence, notes. For each row, Claude assigns a confidence level, high, medium, or low, based on how certain it is the citation is accurate. The notes column flags anything Claude wants to disclaim: a case it suspects may not exist, a quote it generated rather than retrieved, a proposition it knows is a stretch. Then, sort the table by confidence, lowest first. You verify the low confidence rows first. If they all hold up, the high confidence rows are usually fine. If the low confidence rows fail, you've already saved most of the verification time on the rows that do hold up. Claude flags its own weak spots. You verify the low confidence rows first. The protocol is faster because Claude has done the triage. If a junior drafted it, you verify. The case law has shifted in 2026. Senior partners and supervising lawyers are now being sanctioned alongside drafters. The supervisory liability is no longer theoretical. The Casada decision earlier this year set the template, and Q2 cases have built the wall higher. The protocol applies to the senior who signs off, not just the junior who prepared. 15 minutes is short enough to do the verification yourself, even on work a junior produced. The protocol is built so it can be. A junior associate's hallucination is now your hallucination if you signed off without verifying. The new floor for senior practitioners is independent verification, not a junior's assurance that they checked. Now the caveat. Don't ask Claude to verify its own citations. Don't ask another model to verify them either. Verification is a human step against primary sources, always. The reason is not paranoia, it is structural. A model that hallucinated the citation cannot reliably detect that it hallucinated the citation. A second model has its own hallucination patterns and may produce a confident verification of an authority that doesn't exist. The case law on this is unanimous. Verification is a non-delegable duty. Claude prepares the table, you verify the rows. The case law is unanimous on this. Verification was always the filing. The bar has always been, do not file authorities you have not confirmed. The volume changed. The tools changed. The rule didn't. 15 minutes is the new floor for the old rule. Not new ethics, not new duties. The same old rule made workable in the time available. The verification step is the practice now, not the precaution. The senior lawyers who internalize that, who run the 4 checks every time before anything leaves the laptop, are the senior lawyers who don't appear in the database. Coming next, 5 Claude workflows for due diligence. The cross-practice episode for every deal lawyer. Subscribe so you don't miss it. That's the episode. See you in the next one.